Law Talk with Nick Maruchak, thanks to MKI Legal, your trusted employment and family lawyers.
I fought the law and the law won. I fought the law and the law won.
Oh yeah, Nick Maruchak, he joins us right now, live here in the studio from MKI Legal. Thanks for coming in, mate.
Hello, Gary. Great to be here.
How you been? All right? Everything going all right? Work?
Everything's great. Looking forward to the Christmas coming up.
What do you guys do over Christmas out of interest? Do you just sort of have a mandatory kind of shutdown or not?
Yeah, we do the 2 weeks shutdown to force everyone to have a break. Mm-hmm. Most law firms will do that, so that's what we're doing. And have a Christmas party very soon, and it's all going to be really fun.
I always look forward to the law firms' Christmas parties. They're always very good, from what I hear.
Yeah, but we're a lot of us have employment lawyers, so we represent people who get in trouble at Christmas parties. We've done many cases.
Yeah, I take a hint.
I
can take a hint, mate. You don't need me at your Christmas party.
I can't do anything wrong, otherwise everyone in our team knows their rights and I'll just get eaten alive.
Now, but you've got a Ukrainian background, correct?
Yeah.
Well, I can Ukrainian dance. I mean,
you can?
It's a version of that other place where they Cossack dance, and of course I would never say that. I wouldn't want to promote that in front of you. But I can get down there and show you a few moves. So just have a think about the Christmas party scenario.
Is that after you had some drinks? Or?
Usually, yes. That's usually the time. Anyway, that's for another day. And now then, Robin is on the line, Nick. It's a question from Robin in relation to a tenancy in common issue. G'day, Robin.
Oh, hi. Hi, Gary. Hi, Nick. The question is, now, single man buys a home, a few years later, and leaves it right down, only owes minimal, 30 grand. Meets a girl, she moves in, she weasels away on to get her name tenancy in common half share on the title. Now, obviously, things don't turn out. No dependents at all involved, at all, from either party or jointly. Splitting up, any claim on what he owned before he met her.
Yeah, so has this person, were they married, and how long were they in a relationship for? How long were they living together for?
This was met circa 2007 and went on to the title in 2010.
Okay, so they started living together in 2007? Is that
I believe
thereabouts?
So, roughly, yeah.
Okay. So, yes, this girl will have a claim to the assets. Now, the way that sounds like they're in a de facto relationship for quite a long period of time. We're getting well over 15 years here. So there will be a claim. And what happens is the family court gets involved. So the first step is both couples will try and see if they can resolve it, see if they can reach an agreement about how to split everything. And there's a bunch of factors that are taken into account. It depends on who brought the assets in, how much money each person earned during the relationship, stuff like that. But there's no kids, so that's one thing that's important. So if there was kids, generally, say the stay-at-home person will have a bit more rights to the assets than the person who's the primary breadwinner. So they'll have to reach an agreement, and it's important, if they can reach an agreement, to record it in writing, either consent orders or a binding financial agreement. We do consent orders quite cheap. I think we have one of the best rates in Perth. If you can't reach an agreement, you have to go to the family court and you have to fight over it. And that can also get expensive, so it's always better. So looking at this situation just at a high level, potentially, she could be entitled to 50. I mean, it's what happens is, the assets you bring into the relationship do have a lot of weight, but the longer the relationship goes on for, the less weight that it has. So in a short relationship, you kind of walk away what you brought in, right? Longer relationship, 15, 20 years, you start moving more closer to 50-50. So it doesn't actually make a difference if it's joint tenants or tenants in common. The only difference between that two is, say, if there's a death. If there's a death, then tenants in common does not transfer automatically to the other person, whereas joint tenants does. But in this case, it's a separation. They've got to try and, first step is chat it out.
What do you think, Robin? And what do you make of that?
He nearly owned the property when he silly, wasn't thinking straight, lust. Is it called lust, Gary? I hear you talking about lust and love, but...
it starts out as lust, then becomes love, and then it sounds like it becomes what you're talking about now.
Oh, it's not me. It's
No, not
me.
you. I mean, I don't mean you. I just mean what
I'm
the
just-
subject matter.
I'm calling for a friend,
Yes,
it's not me. Goodness, I couldn't be bothered, I'm a bit like, even though we all have our funny ways, I love your stories because I think I live them every day. But, I'm just happy with my Netflix and now and I need, noise cancelling earphones. But apart from that, I'm fine.
Good.
But this is half share, so this is a bit what concerns me, that he's going to lose what he had before he met her.
Yeah.
And then, of course, there was a big extension and a huge big loan. And then, and so now he's kind of got this huge big loan. So if they go to sell this house, he's going to walk away with bugger all, less than what he owned when he met her, if you know what I mean.
Yeah.
Like by the time you take off the encumbrances.
Nick's going to give life advice, not legal advice. I mean, the life advice is that this happened, doesn't it, Nick? And,
Yes.
it's a situation you've got to deal with as best you can. You think through amicable negotiation about it, but that's never always the way, is it?
So the guy should go get legal advice, find out what percentage he's entitled to. He had more assets at the start of the relationship. He owned a house outright, but it was 15, 17 years ago. So, he probably will get a bit more than her, right? Because he brought that in and there's no kids. So he's probably entitled to maybe 60% of it, right? It just depends on how they manage their finances during the relationship. So I've seen some cases where there's no kids and the parties live really independent lives, keep everything separate. Maybe she might be entitled to nothing, but it depends on how they managed it all. But I think I'm leaning towards him getting more, but he should get advice and then try and negotiate with her and do those consent orders up. And the way to protect yourself is doing a prenup, binding financial agreement, they're called, and maybe they cost about $3,000 or $4,000, and it's kind of probably worth it in the long run. So,
Robin, you know the deal, don't you, Robin? There's no such thing as a free roll in the hay.
No, that's what I was saying to them as well. But, never mind, I was a bit sus about it and I thought I'd refer to the specialist just for a bit of early advice. Thank you very much.
Hopefully we've helped you somewhat, Robin. Good luck with it all. Keep watching Netflix as well if you enjoy that. It's 11:45. Nick Maruchak from MKI Legal. If there's anything going on in your life, whether it's something like that, which a little bit complicated when love's involved, and then when people fall out of love, it gets very complicated. 133 882, give us a call. 12 minutes to 12 right now. Nick Maruchak from MKI Legal's here. We've still got time for your calls. 133 882 if you just want some guidance around something that might be going on in your life legally. Hey, just quickly, we just talked about situations that could be put into place to deal with a breakup, right, ahead of time. And you talked about prenups, but someone's asking on the text line, whether or not prenups are something in Western Australia that are binding and upheld. I mean, what can you tell us about prenups here?
So the answer is yes, they are upheld, but there are a few grounds that they can be set aside. So there's some really basic ones. So fraud, right? The big one is when you're getting a prenup, you have to disclose all your assets. Everyone has to go in with eyes wide open, knowing exactly how much the other person owns.
Both sides.
Yep.
So you can't draw up, so this is interesting, you can't draw up a prenup with your lawyer about the situation you're in now, going into with a partner, without the partner knowing all of that detail?
That's right.
Yeah.
All the prenups we do, all the ones we see list the assets in the back of the document. So it's list your assets, their assets, and jointly owned assets.
Must be both sign it.
Yep, you both have to sign it, right? So you need to do that. So that's really important. And a lot of the time they can be set aside. If you've got assets hidden away somewhere and you don't tell the other person and it's a material non-disclosure, it can be set aside. So that's really important. The other big one is a change in circumstances in respect of welfare or care for a child. So this is where they can sometimes be set aside, and this is where it gets a little complicated. You don't have a kid or children at the start, then you have a child. And if the prenup, if it's harder for you to care for and maintain the welfare of the child, then if your chances change dramatically before that child turns 18, that's a weakness in the prenup law. So people can try and get that set aside, right? But there has to be a difference between your financial circumstances because of the child, right? And
But is it like a will? Like if you have a child, do you have to go back to your prenup and say, righto,
review it.
we need to put this in there, because clearly that changes the whole game if there's a kid.
Exactly.
You do that.
So so it's still better than not having a prenup, and a lot of the time, and that's not. It's easier said than done. So someone that has a child and they try to argue to the family court to set aside, they don't always win, right?
Mm-hmm.
So it is a difficulty, but it's good just to if you don't have kids, if you're not planning on having kids, you're later in life, you're less risk, right? We see it a lot of the time.
That's most of the time, is it?
Yeah.
Some second marriage,
Second
time
marriages.
around?
People have been burnt the first time around. They've lost half their stuff, and they don't want to lose half their stuff again. So they get a prenup. So that's a lot of the time. If you're having a child together, and you should, children are wonderful. Get it reviewed every few years, but it's still better than nothing.
All right.
And the other circumstances is something called unconscionable conduct, where you kind of put a prenup in front of someone right before the wedding day, and you say, you don't sign this, wedding's off,
geez.
right? You can't do that. So they've got to go into the whole transaction voluntarily.
Right.
But it's
okay. And is it quite, well, go on, out of interest, fairly common, growing, like in terms of
yes,
prenup? Right.
growing. You're seeing a lot of young people who maybe got inheritance from grandma, right? Getting into a relationship, they want to protect the inheritance. So you can do a prenup just to kind of carve out that inheritance. You say, whatever I got from grandma is mine if we separate, but everything else we built together, we can split 50-50 or however you want, right?
All right. Oh, I like it. All right. I haven't got one, by the way. Too late.
Neither do I. So
no point now. Mark's there. G'day, Mark.
G'day, guys. How we doing?
Good, buddy.
Quick question, I hope. My mother's 86. She's just had a rather serious, recovering from rather a serious medical episode. She's asked, her will is with the public trustee, and for some reason she's asking for me to complete a power of attorney, or she wants to complete a power of attorney, naming me, I guess. Is that necessary? And if it is, what's the easiest way to go about it?
Yes. So what a power of attorney does, and a lot of your listeners will know, it basically allows someone to make financial decisions for that person if they lose mental capacity or right away. So you take the power of attorney document, you go to the bank, you start spending their money and looking after their money. You have to do it in the best interest of the person. So power of attorney applies while you're alive. When you die, it has no effect and the will kicks in. So that's how it works. The easiest way of getting a power of attorney is going online, and they're generally quite cheap for law firms to do, but the government has a really great template you can use. So if you go to just Google enduring power of attorney, go to the wa.gov.au website, and there is a template you can download. Just be careful with it when you're filling out the template. Make sure you follow it properly. But generally, if you follow it properly, you're fine. That's the cheapest, easiest way of doing it. You fill in. Your mum will need to sign it. She has to have full mental capacity for it. And you need to sign it as well. It needs to be witnessed by a JP as well.
Yeah. So your mum's state of mind, everything's fine, is it, Mark?
Yeah, she's fine. She's fine. No problems at all.
So it's a good thing to do, because if you don't have one, then what happens is, say, the benefit of them is something happens to your mum. Yeah. Obviously, then you can just go and start, go to her bank account and spend money for all her expenses, all the medical expenses, nursing home, whatever you want to do. And if you want to be able to sell the house, say if your mum you need to register the power of attorney with Landgate within about 2 months of signing it. Then something happens to your mum, you can sell the house, put the deposit down for the nursing home, and kick on, right? So they're the benefits of it. It just makes it a lot easier. If you don't have one, then you have to go apply to the State Administrative Tribunal, SAT, get an administration order, go through that rigmarole.
And she raised it herself, did she, Mark? So you'll...
Yes,
yeah, okay, got it.
And I was just wondering if the power of attorney supersedes the will that's registered with public trustee.
Separate documents.
Two
different things, right? So they're both. So the will only kicks in. The will deals with splitting assets when you die. Power of attorney deals with giving someone permission to manage your finances when you lose mental capacity or right away. That's how it works.
All right, there you go. Separate thing, mate. It sounds like you need to get on and have it done.
Yep.
Hey, we've run out of time, buddy.
Great. That's been great. I really enjoyed that.
I can't wait for the Christmas party invite. It's coming. Nick Varuchek from MKI Legal. It's 4 minutes to 12.